In the summer of 1787, Governor Morris of Pennsylvania stood in the Constitutional Convention and proposed something radical. Let's give Congress the power to veto any state law that it doesn't like. Well, the room erupted. Delegates from smaller states nearly walked out. Morris had just triggered the fight that would define American government. And that is, who gets to decide? The states or the federal government? Now, this wasn't theoretical politics. Every delegate in the room well remembered a British Parliament overturning colonial laws at will. Massachusetts would ban cruel debt collection practices, and then Parliament would void it. Virginia would try to help small farmers, and the Crown would override it. And for decades, colonists watched distant politicians crush local democracy. So, when the new Constitution gave Congress massive new powers, alarm bells rang all across America. North Carolina took one look and refused to ratify. Rhode Island wouldn't even call a convention. New York's George Clinton published furious essays warning that this new federal government would devour the states, just as Parliament had devoured colonial assemblies. But the most powerful objection came from Virginia's ratifying convention. George Mason, who, by the way, had authored the Virginia Declaration of Rights, which inspired the U.S. Bill of Rights, stood and asked the question that probably everyone was thinking. Where does the Constitution say what powers the states keep? Where's the line? Because without that line, Mason argued, every federal judge and congressman would naturally expand their own power until states became rather meaningless. And Madison initially resisted adding what would become the 10th Amendment. He thought it was obvious that federal government only had the powers specifically listed in the Constitution. Everything else stayed with the states. Why state the obvious? But then Madison watched the ratification fights turn ugly. And the pattern was clear. Americans would reject the Constitution unless they got explicit protection for state power. Now, what's interesting is that Madison's first draft was actually stronger. He wrote that powers not delegated to the federal government were reserved to the states or to the people respectively. But Roger Sherman of Connecticut, he wanted that weakened. He tried to insert the word expressly, making it powers not expressly delegated, which would have crippled federal authority. Well, Madison fought him off, as he did, keeping the language flexible enough for a functioning government, but clear enough to calm the state's fears. The 10th Amendment became essentially the closing statement of the Bill of Rights, the exclamation point, if you will. It said, the federal government gets these specific powers and nothing more. It was America's insurance policy against recreating the British Empire that they had just escaped. But notice that subtle phrase that Madison insisted on keeping, or to the people. The states don't get everything. Some powers don't belong to either Washington or state capitals, but to individuals themselves. Today we still fight this battle. Every argument about whether Washington or state capitals should decide on an issue traces back to that hot summer in Philadelphia when delegates nearly came to blows over who gets to rule. Now, the 10th Amendment did not resolve the federal versus state tension. It simply acknowledged that it existed. It's essentially the founders' admission that a country as vast and diverse as America. Well, in this country, some decisions belong in Washington and others in state capitals. And many belong to no government at all. And by the way, if you've enjoyed this video, please consider liking the video and subscribing to the channel. Thanks.